back to order at 1:00 p.m. We're now here to decide the outcome of Senator Pelton's censure petition against Student Government Productions Chairman Luke Holderman, which has compelled investigation by a joint committee of the Rules and Ethics and Judiciary committees. Before we begin, we're going to retake attendance because we just came back from recess. So, Senator Ruffin, if you want to begin, just state your name.
Connor Ruffin.
Robert Heidi. Marianne Enriquez.
Laura Jane Bryan.
Jonathan Dean.
Aaliyah Lindley. Julia Cypher.
Samantha Kingard.
Aaron Rubai.
Catherine Isaacson. Nicole Gioloni.
Bruce Marcus.
Elizabeth Mizwaski. Vivian Victoria Peters.
And then if you would state your name for the record.
Luke Holderman. Nathaniel Pelton.
And anyone else in the room, can you please state your name for the record?
Alexander Peterson.
Anna Kasai.
Anna Huber.
Raj Man. Tyler Sklar.
Jamie Wong.
Ronan Lupian.
Freddie Rappaport.
So we're going to go ahead and stick with the precedent that we've set with the outline for the hearing. So what we voted on earlier was you'll have an opening statement of 2 minutes. Your testimony and presentation time will be 10 minutes. You'll have a 10-minute Q&A period, and then you'll have a 2-minute closing statement, and then we'll deliberate for 15 minutes. So that's for the committee. So I'm just going to re-go over everything that we went over just so that everyone's clear, especially if you weren't in the room at the time. The outline for the hearing will go, we're going to start with the petitioner, Senator Pelton. You're going to give your opening statement with 2 minutes. Then Chairman Holderman, you'll follow up with your 2 minutes. We're going to go back and forth. Then you'll do your testimony, your Q&A period, closing statement, and then we'll deliberate for 15 minutes. Following deliberations, the committee will conclude one of 2 things. If the committee deems that the charges presented are well-founded, the committee shall report to the Senate a resolution calling for the defendant's censure or expulsion, or if the committee deems the charges to not be well-founded, the committee shall recommend to the Senate that the defendant be exonerated. You're each going to be given equal amount of time to speak, so please don't speak out of turn. I will not tolerate speaking out of turn. Seeing that there was no evidence submitted to me, you are not to use any outside documents. You also cannot cite them in your hearings or any answers to any questions that you received. The only thing you can reference is what was sent in the censure petition. All committee members are also, just to reiterate, also allowed to have a blank page open for notes. Therefore, no need to share your screen, and then I'll be monitoring and timing each segment for the meeting. Before we begin, I'm going to give you both oaths again. Senator Pelton, I'm just going to give you your oaths. Do you solemnly swear or affirm that the information you are about to give to this body is the full and complete truth? Do you solemnly swear or affirm that the information you are about to give to this body is the full and complete truth? Now we're going to start with the opening statement. Senator Pelton, you are free to begin whenever. Your time will start when you begin. You have 2 minutes.
All right, so once again, good afternoon. I'm Nathaniel Pelton, on-campus senator, and in this case, first, once again, I'd like to thank all of the members of the Student Senate Committee on Rules and Ethics and Judiciary for convening. Thank you all for being here today to hear this petition. So today I stand before the committee once again to present the censure of Student Government Productions Executive Agency Head Luke Holderman. The censure resolution entitled Resolution to Censure of Student Government Productions Agency Head Luke Holderman is what this committee shall consider in this hearing. This resolution is authored by Deputy Minority Party Leader Max Bannock, Senator Anna Huber, and myself, with sponsorship from Senators Jackson Ransom, Adriana Sella, Jasil Biju, Ronan Hart, Daniel Permain Ishikan, Arturo Saturday, Marjana Khan, Alan Rivera Jaramillo, Erica Hardin, Arshan Falasiri, Caleb Goldstein, Fasim Islam, Megan Lamy, and Sarah Hoffer. The foundation of this censure rests upon 3 core points, including Cornell Nellie Irolfo Jr. is an individual who has reasonably compelling evidence to assume the acts of sexual assault, sexual misconduct, sexual harassment, sexual grooming, and moral turpitude were committed by the individual. Number 2, Luke Holderman, in this position as Executive Agency Head for the Student Government Productions, pursued and entered into a contract with Haynes Jr. in advance of the evening with Nellie, featuring a musical and speaking performance in violation of Student Body Statute 220.83. And number 3, Luke Holderman, Executive Agency Head for Student Government Productions, further involvement in violating Student Body Statute 220.83 shall be censured in accordance with Student Body Statute 305.1, 305.2, and 307.2 for nonfeasance for their duties as Executive Agency Head of the Student Government Productions Agency. As you'll see from the testimony I provide, the totality of these points is clear. The censuring of Holderman is necessary and justified. Thank you.
Thank you, Senator Pelton. Chairman Holderman, you have 2 minutes whenever you begin.
I want to first take the opportunity to thank everyone for being here today. As Chairman of Student Government Productions, it's my duty to uphold our commitment to enriching the student body's cultural experience by bringing compelling artists to our school. As you've seen in the past, I've been part of composing 5 shows over the last 3 years with amazing artists in attendance. It's always been my utmost desire to do right by the student body and follow the rules and codes set before me. However, it's important to recognize what exactly my role is and what it is not. My job is to interpret the code set before me as well as I possibly can, collect information from the student body and what genre they most desire to see, and execute that desire. Not many of you know me personally, but those that do understand that I wish to act within the guidelines and wish to improve the quality of life for those above my own. In regards to this previous show, I'm truly sorry for anyone that may have been offended by this choice of artist, and wish to clarify some points today by answering any questions that you have for me. I'm aware of the severity of this situation and look forward to clearing up anything today as well as I possibly can.
Thank you, Chairman Holderman. We are now going to move into your testimony and presentation time. You'll have 10 minutes, Senator Pelton, whenever you
All right, so thank you all once again. Once again, the foundation of the censure rests upon 3 core points. Once again, I'm going to repeat them. Cornell, Nellie Earl Haynes Jr. is an individual who has reasonably compelling evidence to assume the acts of sexual assault, sexual misconduct, sexual harassment, sexual grooming, and moral turpitude were committed by the individual. Number 2, Luke Holderman, in the position as Executive Agency Head, pursued and entered into a contract with Haynes Jr. in advance of an evening with Nellie, featuring a musical and speaking performance in violation of Student Body Statute 220.83. And finally, number 3, Luke Holderman, Executive Agency Head for SGP, further involvement in violating Student Body Statute 220.83 shall be censured in accordance with Student Body Statutes 305.1, 305.2, and 307.2 for nonfeasance of his duties as Executive Agency Head for SGP. So first, number 1, Haynes Jr. is an individual who has reasonably compelling evidence to assume the acts of sexual assault, sexual misconduct, sexual harassment, sexual grooming, and moral turpitude were committed by the individual. This is because of 3 core reasons. Number 1, police investigative findings and arrest. An Auburn, Washington police investigation found probable cause of an assault by Haynes Jr. against Green, a 22-year-old student at the University of Washington in the year of 2017. This investigation indicates severe allegations of sexual assault against Nellie. Number 2, civil suit testimonies. A civil suit filed by Monique Green included testimonies of 2 anonymous women who alleged that Nellie sexually assaulted them in separate incidents. These testimonies corroborate the seriousness of the allegations and suggest a pattern of behavior. Number 3, settlement in civil suit. On September 27, 2018, a settlement was reached in the civil suit between Monique Green and Haynes Jr. in the King County Superior Court of the State of Washington, indicating acknowledgement of wrongdoing or harm caused. Number 4, prosecutor's statement. In a statement released by the King County, Washington Prosecutor's Office, Green declined to cooperate with prosecutors because she felt she could not stand against a celebrity and that the criminal system would fail her. Number 5, the Kohler statement. Green's lawyer, Karen Kohler, in a statement released to local media following the settlement, in response to why Green decided to drop the case against Haynes Jr., stated, quote, "We do not live in a society where a 21-year-old college student can feel safe enough to pursue criminal charges against a celebrity for an alleged rape," end quote. She further stated, quote, "As she cries alone in her apartment with mounting hysteria, she will learn that the celebrity and this lawyer are pursuing public statements that her, quote, allegation is devoid of credibility and is motivated by greed and vindictiveness," end quote. That her agenda, and additionally that her agenda is, quote, money, fame, and notoriety, end quote. Number 6, overall pattern of behavior. When considering the totality of evidence, including the police investigation, civil suit testimony, settlement, prosecutor's statement, and media coverage, it becomes clear that there is reasonably compelling evidence to assume that Haynes Jr. has been involved in acts of sexual assault, sexual misconduct, sexual harassment, sexual grooming, and moral turpitude. These allegations are serious and raise concern about the character and behavior of Nellie. In light of these points, it is reasonable to conclude that there is substantial evidence to support the assertion that Nellie has engaged in the specified acts outlined in Student Body Statute 220.83. Number 2, Luke Holderman, in his position as the Executive Agency Head for Student Government Productions Executive Agency, pursued and entered into a contract with Haynes Jr. in advance of an evening with Nellie featuring a musical and speaking performance in violation of Student Body Statute 220.83. This is the case for 3 reasons. Number 1, the same act and Student Body Statute 220.83 itself. On August 1st, 2023, the Student Body Senate of the University of Florida passed Student Senate Bill 2023-1110, this SGP and ACCENT Integrity, Negotiation, and Transparency, same act, authored by Judiciary Chairperson Jonathan C. Stevens and Senator Raj Mia, sponsored by Senator Antonio Hendricks, Majority Party Leader Simone Liang, and Minority Party Leader Bronson Alaman. SSB 2023-1110 passed by unanimous consent in both readings before the Student Senate. Student Body Statute 220.83 states, student government productions shall not pursue or enter into a contract with an organization or persons that have committed the following acts or have reasonably compelling evidence to assume that an act was committed. 1, sexual assault. 2, sexual misconduct. 3, sexual harassment. 4, sexual grooming. 5, dating violence. 6, indecent exposure. 7, sexual exposure to minors. And finally, 8, moral turpitude as defined by Code 307.2, Section 14 of the Body Statutes. Number 2, Student Government Productions entered into a contract with Haynes Jr. for an evening with Nellie featuring a musical and speaking performance. On March 31st, 2024, Student Government Productions announced an evening with Nellie featuring a musical and speaking performance with Cornell and Nellie Oral Haynes Jr. Student Body Statute 220.2 states, student government productions shall exist as an agency of student government in order to provide a well-balanced variety of free and paid entertainment through the academic year. Student government productions shall be the sole student government agency for booking youth-oriented contemporary entertainment and shall coordinate all contractual, financial, promotional, and production details for these productions. This code makes it clear that student government productions is the sole agency responsible for booking youth-oriented contemporary entertainment, including the coordination of all contractual, financial, promotional, and production details for these productions. It is clear, based on these responsibilities, that the Student Government Productions Agency was responsible for contracting Haynes Jr. for the event. Number 3, and finally, Luke Holderman, Student Government Productions Agency Head, was responsible for pursuing and negotiating the contract with Haynes Jr. for an evening with Nellie featuring a musical and speaking performance. Student Body Statute 220.3 states, there shall be a Student Government Productions chairperson who shall be responsible for scheduling entertainment, negotiating contracts, formulating a budget, and overseeing all activities of student government productions. Luke Holderman, in the capacity of Student Government Productions Agency Head, was statutorily responsible for pursuing the contract with Haynes Jr. under Chapter 220 of the Student Body Statutes. The contract was pursued and executed through Student Government Productions with Haynes Jr. for the event in question. Third and finally, Luke Holderman, Executive Agency Head for Student Government Productions, for their involvement in violating Student Body Statute 220.83 shall be censured in accordance with Student Body Statutes 305.1, 305.2, and 307.2 for nonfeasance of their duties as Executive Agency Head for the Student Government Productions Agency. Student Body Statute 305.1 states censure is defined as a resolution passed by the Student Senate in lieu of impeachment. In effect, censure is a written reprimand given to an official whose actions may have warranted impeachment, but the Student Senate felt impeachment was unnecessary. Furthermore, Student Body Statute 305.2 states offenses warranting censure include, but not limited to, the following acts committed while in office: 1, misfeasance; 2, malfeasance; 3, nonfeasance; and 4, abuse of power. Finally, Student Body Statute 307.2 defines nonfeasance as a total neglect of duty as per Black Law's Dictionary. Black Law Dictionary further defines nonfeasance as the neglect or failure of a person to do some act which he ought to do. Luke Holderman, in the position of Executive Agency Head of Student Government Productions, wrongfully committed the act in which is stipulated and in which is stipulated by the contract of the Student Body Statutes, in which the contract states not to do. Student Body Statutes serve as a contract between the Student Senate, the Student Body, and those that elected them, and the executive branch to ensure checks and balances over executive power and to regulate the actions of the University of Florida student government. Luke Holderman wrongfully broke this contract, which, of course, is Student Body Statute 220.83, when he entered into a contract that's stipulated by Student Body Statutes 2.220.2 and Student Body Statute 220.3 with Haynes Jr., an individual with reasonable evidence to conclude the assertion that he is engaged in the specified acts prohibited by the contract. I'd once again like to point out in the opening statement by the defendant that he has served in Student Government Productions and put on productions, 5 of which in a span of 3 years. And he also admitted to having previously worked within the confines of the SANE Act after it was passed, which means he understands the SANE Act. He understands that he's responsible for going out to the public and understanding what speakers they want to see. And he also has a wealth of experience serving in student government productions. And of course, he is the agency head of an agency that has a budget of nearly $800,000 annually. It is our responsibility as a student senate and of this joint committee to ensure that those who commit nonfeasance by neglecting to do their job, a job that's outlined in Student Body Statute 220.83, of which to not bring someone who has allegations or those that have been reasonably assumed to have been committed of sexual assault to this campus, especially during Sexual Assault Awareness Month of all times. So finally, the Joint Committee must respond to this wrongful breakage of contract between the Student Senate of the University of Florida by doing its duty and issuing a censure against Luke Holderman, the agency head of Student Government Productions, for nonfeasance. And thank you, and I yield the rest of my time.
Thank you, Senator Pelton. Chairman Holderman, you have 10 minutes whenever you're ready.
For my testimony?
Yeah.
With the evidence, if I don't have any evidence to show, am I just going to talk about my responsibilities?
Whatever you want to talk about in your testimony.
Okay. Obviously, I'm not here trying to intentionally break acts and codes set forth by the student senate, the student body. That was never my intention. I've had experience doing this job. I've learned along the way. And throughout my responsibilities, obviously, I'm trying to create the best experience for the students here at the university. And in doing so, there are a variety of responsibilities that I have to conduct. Obviously, one of being providing musical entertainment, following the codes that were set forth by the SANE Act, of choosing an artist that is within a certain genre that I have to put out with that survey, and then properly interpreting the rest of that act as well. Obviously, there was definitely some pushback on and some dissent based on the choice, and that was never my intention. However, I'm not the one solely making those decisions either, especially in the content review. There's a lot that goes into that. I get a list of artists from our third-party agent that is available at that date within our price range and can perform. This type of performance was definitely different as well because of the collaboration with ACCENT. We had to find someone that was both comfortable musically as well as the speaking portion as well. I will mention there were a few names that we had on that list before that were not either comfortable doing that type of performance, or they were not available at that date, or was not in our price range. There also were a few in the past on that list as well that actually were convicted of crimes that we struck off of that list. So I'm not intentionally bringing anyone that is breaking crimes and has a criminal record. That's all I have to say.
All right, thank you, Chairman. All right, now we're going to move into our question and answer period. You're each going to have 10 minutes. We're going to start with you, Senator Pelton. So just so everybody knows, if you have a question, go ahead and raise your hand and ask when I acknowledge you. Like when I pick on you, you can go ahead and ask your question. So, does anybody have any questions?
Is there a different threshold? I know we just spoke about accent. Is there a different threshold for research for each position on the background of each individual? Or is it the same as what was mentioned in the previous hearing? And if so, could you please state that back?
Or are you, just for clarification, you're referring to the statute itself?
Yeah.
So they are identical. The only exception being that instead of ACCENT, Speakers Bureau, it states Student Government Productions. But they are exactly identical.
Can you say that for me?
So statute 220.83, which is the one that pertains to student government productions, the one that we're currently dealing with, is identical to statute 221.7, which is the one that pertains specifically to ACCENT speakers.
Yeah. Is there a specific code that talks about the research that goes into the background checks and the codes, or no?
Not that I'm aware of. No.
Any other questions? Alrighty, we're going to move into the question and answer period for Chairman Holderman.
list and have the notoriety and respect of someone who is 21 years old, 20 years old, to accurately get the attention of someone that is going to give you a valuable and accurate price for their show. With the use of a third-party agent, they are able to accurately get a price range for what their shows were in the past, so that we're not spending any additional monies because of that lack of knowledge. So with the use of an agent, it makes it a lot easier and it's a lot more financially responsible to do so with the third-party agent.
Okay, can I follow up? So just to clarify, the only real role of this third-party agent is just kind of like a price, a negotiated price.
Yeah.
Were you aware of the allegations against Nelly before you entered into the contract with him?
I was not aware of those allegations.
Okay, so then follow-up question. If you had known about the allegations earlier, would you have entered into that contract with Nelly?
Obviously not. You know, I'm not getting into a contract. I don't willingly want to have that type of response and bring someone that not everyone is going to enjoy, you know, especially for something like that.
Just to clarify, so you mentioned there were other individuals that had been convicted of crimes, and that conviction is what ultimately led to the decision of them not being
Exactly.
chosen?
I had a criminal record.
Yep.
I appeared in court and was found guilty.
So you mentioned the third party's role was negotiating a price. Who is in charge of, I guess, doing the legal background research, if there is anyone in charge of that?
In making that decision, there's really, you know, I'm kind of the first line of defense in doing that. But the lists that I get are from the third party agent. Obviously, those names that come on that list are people that have performed previously within the last 2 to 3 years, and they're people that have had successful shows as well. So
So you're saying the list is not formed by yourself, but people who will come and perform, you don't?
I don't choose the genre for the SANE Act. The school, the student body does, and based on that genre, I then get a list of names from our agent based on the price range that we specify of artists that have performed that are within our price range previously.
So when you did strike other names off the list, like being on the list, you know, what's kind of like the process you go through to strike them? Like, what was the process to strike those other options off the list?
Well, I mean, we first want to find within the content review if anyone is convicted of, you know, so someone that has appeared in court and has been found guilty is immediately striked off that list. I mean, that's the due diligence that we have to do. Additionally, I mean, we then go through and try and find names that we don't think would fit well with the student body or wouldn't put on a particularly good show that might attract more people to come. So that's where we start, and then we go down that list based on pricing and content and notoriety.
Can I follow up with any? Okay, so when you say that you know, you're kind of looking out for convicted felons, just so I understand, like how do you just like Google their name and like criminal record? Like, how do
Usually
you
that
do
information is given to us with the agent as well. So they'll kind of give us a heads up on what's going on.
But they don't give you any type of like other court cases that weren't found guilty. They don't give you any other type of context. It's just.
Got any more questions?
Can I ask, are you familiar with this act?
I am.
Okay, as a follow-up. How would you define reason to compel evidence?
I think that's what the issue is that reasonably compelling evidence means to me that they appeared in court and were convicted. I think that, you know, if they have an outstanding record of doing that repeatedly, obviously, that's reasonably compelling evidence. But I think that's where some changes can be made to that act, where if that's what you are explicitly wanting us, the rule, to follow, then that's what we will follow. I don't think there should be any room for interpretation.
the only background check you said was the list of criminal convictions that these people had, and that was the only information that you considered provided by the third party.
Any follow-up questions?
What information, how much time is left?
4 minutes. Alright, seeing that there are no more questions, we're gonna go ahead and move into our closing statements. Senator Pelton, you'll begin, you have 2 minutes whenever you are ready.
Alright, so once again, in this case, we're determining whether the defendant has committed nonfeasance. And in this case, the defendant has. The defendant admits doing their due diligence when it comes to other performers, but in this case, they did not. Full background checks have been committed before, but in this instance, they were not done properly. I also would like to point out that the defendant has stated on multiple occasions that they're not the ones who are responsible for coming up with the list, etc. But it really is their job to. Student Body Statute 221.3 states that ACCENT Speakers Bureau chairperson who shall be the chairperson shall be responsible for scheduling entertainment, negotiating contracts, formulating budget, and overseeing all other activities of the agency. And so I find it concerning that the defendant has stated that they have not had the chance to create that list. I'd also like to state that in the stage of this proceeding in which there was testimony provided, the defendant stated that names had been struck off the list for having been charged with crimes. He didn't specify at the time that they were convicted of the crimes. So I'm a bit confused with the confliction there, because if the case is that people were struck off of the list for having been charged with crimes, I'd like to once again state that Nellie has been charged with this crime on multiple occasions, although not found guilty. And so I have a very serious issue with this. At the end of the day, the rule of law exists for a very distinct purpose. It's that all individuals who are subjected to the law must follow and abide by that law. And they don't necessarily have to be told by anyone that the law exists. They have to abide by it regardless of that fact. In this particular case, Luke Holderman, in their capacity as the Student Government Productions Agency Head, did not abide by the law as set forth, a law that he himself admits he is well aware of, especially considering that he has spent 3 years in student government production and has put on 5 shows himself. So I take serious issue with this. And once again, I just want to state that our job is to determine whether this individual has committed nonfeasance. I believe, based on the evidence that's been provided and all the testimony and question and answer, that in this particular case, nonfeasance has in fact transpired, and for that reason, we must recommend this to the Senate floor. Thank you.
Thank you, Senator Pelton. Chairman Holderman, you have 2 minutes whenever you're ready.
I want to again state my prerogative in this matter was always for the betterment of the student experience and not one of ill intention. I do think that the ambiguity of the Act leaves room for interpretation and should be looked at a later time to ensure that future chairs don't have to interpret this wording. If simply being accused of an act is all would like to be conveyed, certain change of that wording should take place. This change would certainly alter the way we conduct content reviews in the future, and if being accused of something constitutes the artist for being removed from contention, this pool size of available talent considerably shrinks. I want to thank you all for being here and hearing what I have to say, and I've enjoyed being here as well, cooperating with you as best of my ability.
Thank you, Chairman Holderman. All right, so now we're going to have 15 minutes for deliberations. Committee members are the only ones that have speaking privileges. If you are not on the joint committee, please do not speak. We're going to do this, and like you guys can just speak freely. You don't have to raise your hand or anything. It's more of a conversation.
Point of personal privilege. Can I address the committee? Would we like to make a motion that it's a hand raise? No? That's, I'm fine. I just want to know. That's fair.
15 minutes right now.
Alrighty, so a lot of the same things that were mentioned in the previous entry here are echoing here as well. I do think, once again, that nonfeasance is a reasonable conclusion of the events that transpired. Although I don't believe, as it is not specified, that it is solely the responsibility of SGP to look into the background and scan a full background check of the applicants or of the people that are selected for this pool of performers. I do think that they play a role in this process, and in this instance, that role could have been accomplished better. There could have been more due diligence. I mean, I do think that, in part, that, again, this also specifies malfeasance as one of the charges on here, not just nonfeasance. It's the same as the previous censure. And again, I would like to clarify, first of all, that when I asked the defendant about whether or not people have been stricken, he indicated that it was for convictions. And that is important for a number of reasons, primarily because it shows that this law can be applied differently depending on different stages of the criminal process. I understand that we're here to decide whether or not these charges apply to this law, and my point is, without knowledge of these crimes, because of the negligence, because of the lack of due diligence, there was no willful intent to break this code. Furthermore, it could also be argued that there are different points along this process that wouldn't constitute reasonably convincing evidence, compelling evidence. If conviction is, again, I've mentioned this before, if conviction is what we want, or if accusation is what we want, Senate needs to specify this. I in part blame Senate for the failure of this application for this Nelly performance. I think that the lack of knowledge about the specific charges against Nelly does constitute nonfeasance, but it was not willful. There was no intent to this action to break the codes. It could be argued by chairs in the future that pure accusations did not constitute this. And my argument with the malfeasance part of this is that it implies that there was a willful breaking of the codes. We can't assume that any chair of ACCENT or SGP will have the same opinion on reasonably compelling evidence that we do. So therefore, we're going to keep running into this problem over and over again. So overall, again, I'm going to recommend and say that I think that the malfeasance charge should be stricken, purely because there was no intent behind this decision. I mean, we heard in the testimony and in the question and answer period that if there had been knowledge of this incident, of these charges, that Nelly would not have been chosen for this role, for this production. So, I mean, that's overall what I have to say. I do want to say that some of this does fall on SGP. Absolutely. There has to be increased awareness of these background checks in the future. If we want them to scan for non-conviction offenses or things that have been settled out of court, we should specify that and make sure that they are the ones doing this instead of a third-party agent. But as it is not specified in terms of background checks, I just think that malfeasance would be overstepping our reach on this. But nonfeasance would be applicable.
To add to Chairman Rubai's point, I also think from the agency head's own words that if they were only looking at people with convictions, then how can we say that it was nonfeasance? I mean, if they went through what they believed were the parameters to remove people from the list, which were criminal convictions, then can we say that he didn't do his due diligence in making sure that the best people could go before the go before SGP?
Yeah, okay. So, sorry. I'll just do this quickly. I want to break down the levels of responsibility in this situation with regards to nonfeasance, because that's what we're talking about, so we're all on the same page, right? So, his responsibility was to enter the contract, as Senator Pelton said, coordinate contractual, financial, and production details. It was also his responsibility, but not solely his responsibility, to do some level of research and background checks. And then, while I do not agree with the decision to bring in Nelly, given the information that's available upon a Wikipedia search, I also believe that it is not Luke's responsibility to determine what is reasonably compelling evidence, given that Nelly's case was in fact settled at a civil suit. We know that Senator Pelton defined reasonably compelling evidence as the probable cause that came from the accusation that led to the arrest, as stated in the last case. But it seems like here there's a totally different definition, which is, let's see, that someone has appeared in court and were convicted, or that they were just accused repeatedly and convicted. So, by those parameters, while sexual assault obviously is not a good thing, we do not want people who have committed sexual assault to be giving these types of shows. I, again, don't think that the burden should fall on the ACCENT and SGP chairs to solely determine whether someone has enough reasonable evidence against them for sexual assault, because that is, again, a due process issue. And I would argue that we need to reform the SAINT Act to add these types of parameters, and this is something that we can definitely do. The truth of the matter is, Luke Holderman's responsibility was to choose the best performer or speaker for the student body, And by his beliefs, he did that. So, I stand by my point.
Okay, so I do want to touch on what Majority Party Leader Cypher said as well as what Senator Rothman said. Okay, especially the thing about it not being nonfeasance. So I do want to bring up that Chair Holderman said that he wasn't aware of these allegations. At the same time, he did say he was aware of the code. So he is aware of state, right? He also in Q&A said that he's the first line of defense when it comes to checking these legal issues, but then also said that he didn't follow up with the list given to him by that third party. But he is aware of the code that he has to abide by, and he is supposed to be, according to his own word, the first line of defense, but then he also wasn't aware of the allegation. So, looking at all of that and using, just like based on the questions and the answers to the questions from Chairman Holderman, it does seem like there was, at least at a bare minimum, a level of nonfeasance. So I do agree that, I don't agree that there was no nonfeasance here. I think that that's like the bare minimum. And then going beyond that, I'm just thinking about what you said. Okay, I'll leave that there for now. I think there's definitely a lot of contradictions in what this individual claims that their job was and then what they actually did or how it was actually handled. But I'll leave it there for now.
I was just going to say something very similar in that it is, in the responsibilities, there is a description that part of his role is to be in charge of sort of screening these individuals or at least doing research. But I just feel like the mere fact that he wasn't aware of these allegations at all, which he said he wasn't aware of them at all, does constitute nonfeasance. And just a lack of Googling the person.
I just want to say that that's not actually in his role. Like, that's not prescribed as part of his role.
So we asked that during the questions, we asked whose job is it, and he responded that
He is the first line of defense. There's nothing
Right.
prescribed in the code that is part of the role of either of the chairmen that we have spoken to
So
today.
then what does first line of defense do?
I'm just saying it's not a prescribed role. He's just saying like it's a responsibility to take
Okay.
on, but it's not a prescribed role.
I think the reasonable conclusion from this is that it's an implied job requirement for this, and that is why I contend that nonfeasance is the applicable charge. Because if there's a breach of an implied role that isn't written down, that we could have assumed there could have been more done to prevent something like this from happening, nonfeasance is reasonable. But malfeasance, again, based on the amount of willingness and intent to go beyond into extra legal territory, into illegal territory, when there's no specified role that they have to do this, would not apply to the defendant.
I'd also like to say I agree with Majority Party Leader Cypher that this does need to be a much stricter rule. There need to be more parameters. But I'd also like to say that I think we're kind of considering it a bit too narrowly. It does specifically say acts committed or have reasonably compelling evidence, and if we restrict it just to convictions, I think we're kind of ruling out that part that says have reasonably compelling evidence. I'd also like to say that I don't think we're here to convict Nelly of anything. That's not our job. But I think we're supposed to kind of determine whether there was a possibility of guilt, and considering there was an arrest, I think that does kind of constitute his being part of this job.
Okay, first of all, I have a problem with that statement. Reasonably compelling evidence is one thing. Having someone accused and in court does not constitute guilt. Absolutely not. That's a violation of due process and everything that we value in our criminal justice system. That is the primary issue, is that when you have statements like reasonably compelling evidence, where you have to draw a line, we can draw it as early as accusation. That's totally within our authority to do as a student government. The problem is we did not. And because we did not, there's different interpretations as to what would constitute guilt. Because it is next to in the codes, guilt, it's assuming that it's a threshold relatively high or akin to guilt. And because we can't assume that a non-lawyer and a non-judge, non-jury undergraduate student can determine guilt, it's just not possible and not good if they were trying to do that, that we can understandably disagree and wish and encourage more action on background checks in the future, but we should not be encouraging them to make these unilateral decisions, as I mentioned in the previous case.
to Chairman Ruba's point, I mean, it says that reasonably compelling evidence to assume that an act was committed. If we are to say that, in a court of law that this person did not have their charges go through, therefore it technically did not, it wasn't committed under the eyes of the law. And I think that is something we need to look at here, because the agency head himself said that we look at people convicted of crimes with a criminal background. So I think that is where the language comes into issue. Are we looking at someone who was accused of something? Are we going to just throw out everyone and consider everyone accused of something as guilty and therefore ineligible to be a part of this process? Or are we just going to look at those who have been convicted of a crime?
I'd like to point out, just so everyone is aware, that the settlement that occurred in this case is not the same as having legal liability. In fact, it explicitly is not considered legal liability on behalf of the defendant. So, although we may assume that because the probable cause, which led to the arrest, which led to the settlement, was enough evidence to assume that Nellie was guilty of the crimes that were alleged, they were not upheld fully. He was not convicted, and a settlement, which I understand some may deem as more compelling than others, but the fact of the matter is he was not held legally, criminally liable for the actions that he committed. So, again, I think we all agree that there needs to be a higher standard by which we judge the people that come to perform at ACCENT and SGP events. I think there should have been, in this instance, more research on behalf of not only SGP, but also help on behalf of Senate or third-party agents that make sure that this does not happen. There should have been more research on behalf of SGP, but we can't put the blame solely on them. But because there is some element of blame to this, that it led to the possible breaking of the codes, I think that negligence would lead to nonfeasance. But even considering malfeasance in this case just doesn't make sense. Yeah.
How much time is left in the room?
2 minutes.
2 minutes? Okay. I do want to just reference Pelton's presentation, saying that some of these charges were dropped because the individual who was making the accusations was a 21-year-old student, a college student making an accusation against a celebrity with, very high-profile lawyers and that kind of thing. And also, we can also maybe take into account the fact that this may have been dropped due to the mental and emotional stress put on the individual, but I guess I'll digress on that. I do also want to say that I don't think it was this individual's responsibility to convict Nellie. I agree. He's not supposed to make a judgment call in a court of law. Agreed. But it is on student government productions to make these decisions to protect the student body and to just provide something, that is enriching for students. And when you say, whose decision, or beyond this individual, who's supposed to make that call now? Well, it is supposed to be us, And so I don't think we should just be going based off of technically here and here, we are supposed to be, as this individual is supposed to be, making that judgment call based on this list that is in code. And then I also wanted to say, what was the last point you made? I don't remember. Oh, the thing about Senate, it was actually struck down by the executive branch that Senate approves the speakers that ACCENT and SGP brings. That was struck down because apparently it was an overreach of legislative power onto the executive branch. So that is actually something that we tried to do with the SANE Act, and we had to strike it in order to pass the SANE Act. So I don't think that that's fair to bring up in this, because we're not debating the code, we're debating whether or not this individual broke the code. So I don't think that that's fair to bring up.
Okay, we have 10 seconds left, so I'm just going to say this real quick. The reason why we're talking so much about this case in the actual clause is because a part of Nathaniel Pelton's reasoning was that Nellie, there was reasonable evidence found to assume sexual assault.
Deliberation has ended. Do I hear any motions?
I move to strike the second to last, therefore let it further be resolved clause that includes the statement censuring Student Body Statutes Agency Head Holderman for malfeasance by unanimous consent.
Is there a motion to strike the aforementioned clause from the resolution by unanimous consent? Are there any objections? Hearing none, the motion passes.
Follow up. I move to recommend this censure of Student Body Statutes Agency Head Holderman to the floor of the Senate, containing only the charge of nonfeasance in accordance with codes 35.1, 35.2, and 37.2 by unanimous consent.
So there's been a motion to recommend the resolution to censure Student Government Productions Agency Head Holderman with only the charge of nonfeasance to the Student Senate by unanimous consent. Are there any objections? Hearing none, the motion passes. Seeing that all business has been heard, I adjourn this meeting at 5:47.
Hey.
You drive here?
Yeah.
I was gonna drive you back.
I'll come back to your house.
Thank you everyone for coming. I know Wednesday is difficult.
Thank you. You did a great job. Jenny, you did a fantastic job. Thank you for all as always.
I think that was.
You'll make a good lawyer.
I was just going to say, I would love to serve on a legal team with you because I feel like we would
Your
kill
closing
it.
statements, I'm very impressed by. I don't know if you've done mock trial before.
No, I'm going to get
I don't know if you've done Cabin Christian. I did
I have
mock
not.
trial where he actually. I met him before I was in student government. He'd be very good.
sure.
Just
Well, you are good, so congrats.
If anyone wants to know the phase on 10th of the bill, I'm the one that wrote it.